Good morning, everyone. I welcome you all to our free and introductory session on civil litigation. My name is Henna. I'm a barrister and solicitor in the province of Ontario, and nothing I discuss today constitutes legal advice. It does not give rise to any solicitor-client or barrister-client relation between us, and that includes fiduciary, contractual, professional, and agency relation. Whatever I will discuss over the course of next few hours is only meant for educational purposes. In addition, you're strictly prohibited from recording this session, and in the event you do so, not only will you be breaching my privacy, but you shall be breaching the privacy of every single candidate attending today's session. Please note the materials that I have prepared exclusively belong to me. They can neither be printed nor be downloaded and must not be accessed in any unauthorized fashion. Furthermore, I request you all not to ask any questions stemming from the examination content as defined by the Law Society of Ontario in your respective lawyer licensing agreements, lest it jeopardizes the process for everyone else. With that said, I will start sharing my screen, and we are going to start with the very first topic, which is on civil litigation. Each class is going to be, in every class, we're going to have plenty of practice questions, which we will go over once the class is done. And the reason for doing these practice questions is to understand whether the concept has fully settled in or not. You will see as we will progress that the practice questions also have a substantial PR component, and that is because it is advisable to not study any practice area on its own. You must tie it up with the concepts of PR so that you're able to not just understand a particular concept from the substantive law aspect, but also add an element of professional responsibility, especially in real life scenarios when you will have, when a lawyer client relationship has come into existence. How are you going to deal with a particular issue, whether it's withdrawal, whether it's conflict, whether it is running a trauma informed practice, whether it is about handling your firm, as in practice management related questions, deciding the fee aspect. So you will see that the concepts have then been tied with the PR aspect, and that'll help you understand the concepts better. With that said, let me start off with civil litigation. So you see, civil litigation is one of the largest components of your barrister exam, right? If you will look at the website of Law Society of Ontario, you would realize that you have to display entry level competencies. What I mean by that is that when you are writing your barrister exam, you are going to be tested on these competencies, right? Ethical and professional, which is what I was discussing like a couple of minutes ago. Knowledge of law, which is where we are going to talk about the substance of civil litigation or family or criminal or PR. Establishing barrister-client relationship, problem issue identification, analysis, and assessment, alternate dispute resolution, the entire litigation process. This is about the procedural aspect. Like, for instance, you filed a statement of claim, and then what are your next steps? You filed a statement of defense, and what are your next steps? How does my litigation or my matter end without really getting into trial? Is there a motion that I can file? What if I need to sue the plaintiff for the loss that I have sustained? What are the subsidiary claims? So litigation process, in fact, focuses a lot on the procedural aspect of law. And as you know, that this process is undergoing a massive change. In fact, your rules of civil procedure are going to witness a sea change, especially with regard to the rules that have now been discussed. In fact, they are at a very advanced stage. The chair of and the working committee presented these rules to 1,700 lawyers across Ontario, and they've had two consultation papers so far about how these rules are going to look like. What are the matters? How will the matters Like your for instance, your summary procedure threshold will change, right? Currently it's 200,000, they're planning to make it to 500,000. Your statement of claim will go. So the rules are going to see like an entire refurbishment, because the rules that we study today are from 1985. So pretty much there has not been an overhaul for the last 40 years. And then, of course, the practice management issues that we are going to deal with. So during your practice sessions, I'm going to ask you, before we even look at the answer, read the question and ask yourself, which competency am I being tested on? What is it that the examiner wants me to see in this question? Because, there is a very old saying that I believe in, that a good instructor will tell you where to, where to look, but not teach you what to see. Because that is something that you will have to be able to sort of identify yourself when you read the question. Which competency is being tested? Are they testing my do they want to see whether I understand the litigation process properly or not? Do they want to assess whether I completely understand and grasp the nuances of barrister-client relationship or not? Do I need to, you know, am I required to do a problem identification here? Is the focus of the question ADR? So on and so forth. So it is crucial that we focus on what is it that I'm going to be tested on, right? So that becomes very important. Now, before I get into the nuances, there are essentially three stages to any civil litigation file. And it does not matter, the amount does not matter. It does not matter how trivial it is. If it is a civil problem, right, it will have these three stages. First, pre-litigation protocols, or before commencing the litigation. Second, what happens once the litigation has started. And finally, when you go to trial. You would be surprised to know that most of the files, over 90% of the files, end at that stage, because after the discovery stage, people usually want to settle. Very few files actually progress to the trial stage, right? And at any, whenever we think of being lawyers, we think of, oh, we want to take this matter to trial. Does not happen with every file and is not even encouraged, because trials are prohibitively expensive. So from PR perspective, you will come to know that it is often said that do not be trigger happy, do not be litigious. The days of litigator gladiator are gone, right? And therefore it is important that at all times you impress upon your client the importance of ADR in settling, right? So over a period of time, we have seen a perception change in how people want to deal with civil litigation files. Because my firm does a lot of civil litigation, like we essentially do a lot of labor and employment, we do civil litigation, and we do a lot of real estate. I run my own law firm by the name of Mall and Shibber Law. So because we do a lot of civil litigation files, it is imperative that we follow these pre-litigation protocols, that we tell the client after having received everything, that it is important to settle. Because at no point in time can your lawyering go away from your PR responsibility. So before commencing litigation, commencement of litigation, and finally trial. Now, the trial will either end at with judgment or will lead to an appeal. If it ends with judgment and you're not happy with judgment, you go in for appeal. That is one route. The other is neither party appeals and you want this matter, or you want the settlement or judgment to be enforced. So this is how your civil litigation file, and like I said, any and every civil litigation file will flow. So, and what I have done is I have broken down each of these stages to further substages. Like, for instance, before you start the litigation, it is important to understand the jurisdiction and organization of courts. During my practice focus sessions, which I'll be starting very soon, I will in fact talk about which court you need to go to under what circumstances. Let me tell you, plenty of lawyers, especially newbies, end up spending a lot of time trying to figure out where do I go for this matter? Whom do I approach? And if they don't understand anything, they just go to SCJ, and the SCJ, that's your Superior Court of Justice. And then they end up saying, but we don't have jurisdiction. So jurisdictional issues are the number one issues which new lawyers tend to get confused with. And when I'll be starting my practice area specific session soon, where I'll be talking about jurisdiction of court. Where do I go? This is the stage where you have to ask yourself, where do I go? And let me tell you, after we are done with today's session, you would ask, if I'll ask you questions, you'd still get confused. And therefore, that's where practice session comes in. So that practice questions come in so that you're able to test yourself at every stage. Check if there is a cause of action. Please do not encourage frivolous litigation. So before you start the litigation, understand the jurisdiction and organization of courts, understand if there is a cause of action, check if any demand notices have been served. Have you sent a letter of demand to the other side? Do you need to file any notice of constitutional questions? You will study more about these when you do your public law. What is a notice of constitutional question? When is it that you need to send it? To whom do you send notices when you're dealing with a novel claim or when you are dealing with a notice of constitutional question? Check if the matter is within limitation period or not. These limitation periods are going to going to go undergo a sea change. What is the appropriate forum of the matter? If the claim is over $200,000, excluding interest and cost, then you will go for ordinary procedure. Otherwise, if the claim is less than $200,000, you will go for simplified procedure. Under the new rules that they are planning to propose, this limit is going to change. They are going to suggest $500,000 for summary procedure, but you don't need to know about it right now. You need to stick to what is the existing limit. But just to let you know, because as we are going to progress, I will give you, while it's important that you understand civil litigation, it is also equally important to understand how will it look like. Because when you will do your practice questions, you will realize that sometimes you'd be like, oh, but the answer was not in my materials. Well, the answer was not in your materials because you've not really understood the rules properly. You've not focused on the rules. You have not been able to tie down the service rule with limitation period, and perhaps, you have used an incorrect form of service, and therefore, as a result of that, there is a default noting, and the judge feels that there is no genuine triable issue, and the default noting is now they are not going to remove it. So you see, there are three rules that are coming into interplay. And that's why candidates find civil litigation very, very challenging. Hence, it's important to understand how will they look like. On some occasions, I'll actually open the rules in front of you and say, let's read this rule with this rule and combine the two. Because that is how you'd be able to perform well in your practice questions and, of course, eventually in your exam. You need to identify the parties involved. Any kind of parties, if they're reeling under disability of any kind, can you take instructions from them? Have you named all the necessary parties? Have all parties been made? Or have all the necessary parties been added to your lawsuit? So these are your pre litigation protocols. Once the litigation has started, you need to decide whether you're going to start an action proceeding or an application proceeding. The two are very different, and we are going to talk about it. When do you file an action proceeding and when do you file uh, like an application proceeding. You need to fulfill the requirements of the originating process. You will have to get the documents issued. What does this mean? Why why are we talking about getting these documents issued? Who issues the documents? Can you just stand in a queue and say, get my documents issued? How does that work? Serving the documents. Service is a very important part because people try and evade service at all stages. So, how will you then ensure that the documents are served properly? Preparing the pleadings. Check if there are any grounds for dispensing with trial. Like here, we are talking about when we are bringing a litigation, when we are stopping the litigation in its tracks. How does that look like? It is here that we're going to look at various motions that you're going to file. And believe me, even after you've understood these motions theoretically, when I will ask you which is the most appropriate motion in this circumstance, chances are that you will not be able to give me the right answer because it is so easy to get confused between a summary judgment and, let's say, determining an issue before a trial, or this the the file does not have an issue that deserves a trial. So it is so easy to get confused between Rule 20 and Rule 21. And that is why, from knowledge of law perspective and litigation process perspective, candidates tend to get confused. So these are the various motions that stop a litigation file in its tracks. Then we are going to look at check for subsidiary claims. You might want to file a counterclaim, a cross claim, a third party claim. What is the difference between all three, like amongst these three? I will let you know. Do you need to file any other motion? Like, for instance, what if you want to amend a pleading? What if you want to strike out someone's defense or pleading? When do you file for a motion for substituted service? What exactly is a motion? Most people, and I ask them, give me the difference between what is the difference between a hearing and a motion? What is the difference between a case conference and a motion? And that's where people are like, I think we know the answer no. You have to be very clear. Is this a case conference or are you bringing about a motion? Then, of course, discovery of documents. This is huge. This entire process will obviously undergo a massive change in when they bring in the new rules. Discovery plan, examination, inspection of property, all these are set to undergo changes, but not for your exam that is going to take place in February 2026 because they're planning to roll out the changes only by the mid of next year. So those of you who are planning to write in June 2026, you might have to study a lot from, the new rules perspective. So that's what I'm saying. If you are somehow prepared for February, write your barristers in February. Otherwise, a lot of it is going to change. Case conference and offers to settle. Finally, from trial perspective, how do you prepare for a trial? What is an opening statement? Introducing issues and evidence, examination in chief, cross examination, what is a re examination, and then what are your closing arguments and statements. I'm in the process of drafting two closings. This, I personally think closing arguments win the case for you. My articling principle used to think witnesses win the case for you. My partner in law firm thinks that you have to have a very strong opening. So I think all of us have differing opinions. My partner thinks you have to have a very strong opening statement. And I go like, yeah, but people are going to forget, right? You want them to have what you speak in the end as the last thing that they remember. My articling principle used to say that witnesses win the case for you. So I think all of us, you will come to your own conclusions once you start litigating. It's a lot of fun, believe me. Um, Once you start litigating, which is your favorite part? Like, I personally like closings the most. And finally, post-trial. So what happens if the trial is over? You'll get your order, the difference between order and judgment. How do you enforce an order? If you're not happy with your order, when do you appeal? Where do you appeal? Most candidates get confused between where do I go for appeal. So it's not just from the standpoint of where do I start my case, but also where do I appeal. And it is here that we're going to talk about appeals. Now, let's look at this stage before litigation, because this is what we're going to be focusing on. Now, when you look at the structure and jurisdiction of courts in Ontario, there is an act which is known as the Court of Justice Act. Court of Justice Act puts the structure. Think of it as an act that's giving you the skeleton that sets the entire court system in Ontario, right? So for instance, how do you calculate your prejudgment, post-judgment interest? All these things actually flow from the Court of Justice Act. The Court of Justice Act has created two types of courts, Court of Appeal and Ontario Court, right? When we look at Court of Ontario or Ontario Court, we are further split into Superior Court of Justice and Ontario Court of Justice. This the justice is missing over here. I mean, because this box is too small, but Superior Court of Justice and Ontario Court of Justice, right? When we look at Superior Court of Justice, Superior Court of Justice are essentially your Section 96 courts. Now you might go like, Section 96 of what? So those of you who have studied constitutional law, you would know that you had something called the British North America Act at one point in time, which is now your Constitution Act. Under that, there is something called Section 96. Section 96, in fact, establishes your court structure in Ontario, right? Section 96 has created between Section 96 to Section 100, your court systems in Ontario have been created. So Section 96 are those courts that are courts of inherent jurisdiction, where no court is ready to take um, jurisdiction over a matter. Superior Court of Justice is that court that takes jurisdiction. Why? Because it is a Section 96 court that has been established as per the Constitution. So when we look at Superior Court of Justice, we are looking at courts of inherent jurisdiction. For those of you who are not familiar with the concept of inherent jurisdiction, let me explain it to you what it truly means. It means that if no one is ready to take jurisdiction on that matter, we will come to us, right? There's a lot of history behind it, but we are not really going to get into that. We just need to focus on the fact that when we are talking about Superior Court of Justice, we are talking about courts of inherent jurisdiction, right? And Superior Court of Justice has four branches, right? Let's look at those branches. Divisional Court, family division. We are going to study more on this when we are going to do family law. Small claims court, specialized courts, right? So Court of Ontario is divided into two types: Superior Court of Justice, Ontario Court of Justice. Superior Court is further subdivided into four: divisional, family, small claims, specialized. We are going to park family division for now because we're going to come to it when I do family law with you. As far as this session is concerned, for the purpose of civil litigation, we will be focusing on divisional courts and small claims courts. And of course, we're also going to be talking about Superior Court of Justice as such. Ontario Court of Justice does not have civil jurisdiction. So Ontario Court of Justice essentially has criminal jurisdiction, and we are going to talk about it when we do criminal procedure or criminal litigation. Any issues so far? Is the code structure clear to everybody, or do we have questions here? Tani, Ehsan, Uche, Divya, Sweet Mother, Deepak, Zina, Nomi, Aarti, Tabassum, Rehan, Oki, Ayan, Dalila, RM, Blackberry, AB, Angela, Rima. Any questions so far? What we have studied, what is the focus of civil litigation? Anything that you want me to repeat? Guys, we're going to take some time understanding the basics. If we don't understand the basics, then it's an issue. So I want to know if the basics are clear at this point. Okay, I'm going to assume that they are, if you have no further questions. The Court of Appeal in Ontario is the court which is of the highest level, and it hears appeals from Ontario Court of Justice and Superior Court of Justice. All the issues that go from Ontario Court of Justice, like I said, it does not have civil jurisdiction. It only has criminal jurisdiction. An appeal from OCJ lies to OMCA, which is Ontario Court of Appeal. When it comes to Superior Court of Justice, all the appeals from SCJ go to Ontario Court of Appeal. Let's understand the technical competency. Now, there are essentially two official languages in courts of Ontario, English and French. A party that speaks in French has a right to require the matter to be conducted as a bilingual proceeding. So you have a right to ask for the matter to be conducted in both English and French, or ask for like a exclusive this thing in French. How do you initiate a proceeding in French? You have to file the very first document in French, right? So you have to file the very first document in French, or have the registrar issue the first document in French. So the very first document, whether it's your statement of claim, whether it is your notice of action, notice of application, that needs to be filed in French, or tell the registrar that the first document needs to be issued in French. If the document is filed or issued, so for those of you who are not familiar with what is issuing, issuing is a process where the registrar signs the document, seals the document, and assigns it a court file number, right? Before that, your claim has not, so to speak, taken birth. So once your documents are issued, we say a claim is born. Like in the eyes of court, you now have a claim. So if that document, basically that is known as the issuing process. We are going to talk about what is an originating process at a later stage to explain this to you in a much deeper fashion. If the document is filed or issued 7 days before the hearing, the party requires, you are required to bring a motion in the court saying that, we need the hearing to be conducted in French. And this is when, if you file the document or get the document issued 7 days before the hearing. If the action is in Superior Court of Justice, the application must be filed prior to the action being placed on trial. So if now the matter has proceeded to trial, then you need to then bring in the application right before the matter is placed on trial. If it is in small claims court, it must be filed with a notice of trial. And what happens if the document is filed or issued less than 7 days before the hearing? Well, then you're not entitled to have a hearing in French, but you may bring in a court order saying that a judge who's fully bilingual should hear the proceeding. Alternatively, A party may file a requisition or a written statement. You can make an oral request to the court that we want the proceedings to be in French. Now, when we look at jurisdiction, like I said, we are looking at two types of courts: Court of Appeal and Court of Ontario. When we look at Court of Ontario, they are further subdivided. So, Court of Appeal has two types of jurisdictions: original and appellate. Original jurisdiction, essentially, if there are any questions, reference questions that come from the cabinet or lieutenant governor in council, they are heard here, court of original jurisdiction. What is appellate jurisdiction? Appellate jurisdiction essentially means that the matter is now going to proceed in appeal. When you're not happy with, let's say, the decision of Ontario Court of Justice or Superior Court of Justice, you file an appeal. There are proper appeal procedures. So the jurisdiction that or Ontario Court of Appeal has appellate jurisdiction, which basically means all the orders passed by Superior Court of Justice, they are appealed before Court of Appeal. Orders where the superior, where the claim amount is over $50,000. So let's say um, order has come from Superior Court of Justice, value of which is $45,000. Do you think it's going to go to Ontario Court of Appeal? Let's say Superior Court of Justice has given an order for $42,000 against you. You're not happy with the decision of the judge. You want to appeal. Are you going to go to Ontario Court of Appeal for that? Where are you going to go? We haven't done that yet. But let's say if the value of that order is $55,000, now where will you go? A decision has come from Superior Court of Justice. Value of that decision or the amount that is mentioned in the decision is $60,000. You're not happy with the decision of the court. Where are you going to go and appeal that decision? I need answers because until and unless I have this answer, I'm not sure whether you understood, and then we cannot progress further. So if you want course completed,
Madam, I think we will go to.
yes. Where will you go, Esan?
Madam, I think we will go to the Ontario Court of Appeal.
Yes, you're absolutely right.
Madam, Ontario Court of Appeal.
You're absolutely right. Value of the order is above $50,000. It's a no-brainer. Court of Appeal. And if you want, you can write these pointers somewhere so that you know exactly which court to go to. Believe me, when you will start doing your practice questions, you will find it difficult to figure out where do I go from here. So you need to be very, very clear about your jurisdiction. I call it the jurisdictional hopscotch. If you're not clear, too bad. You're going to lose marks, especially from in litigation process, because you cannot afford to get this wrong. This is basic. And these are those questions which will not take too much time when you're going to read the question because you know it's a jurisdiction question, you already know the answer. So these are time saving. You'll end up perhaps answering these questions in 30 seconds to 45 seconds. And if you know the answer, there is no way you're going to go wrong. So these are the areas in the exam where you score. Like for instance, personally, anything to do with substantive and litigation process was a breeze for me. I used to spend a lot of time reading PR questions because they were confusing. When you're looking at the substance and the process, that's where you need to be very, very clear. Otherwise, you can forget about finishing your paper on time. You should be able to finish your paper on time. You should be able to answer these questions: jurisdiction, court, process, subsidiary claim. Where do I go? What do I file? How much time do I have? Limitation over or not? This process, anything related to process should be automatic. You should not spend time either reading it or thinking about it. It's like if you come to me and say, Hina, I have a claim, I will ask you two, three questions and I'll know exactly. The answer is divisional code, Delilah. We're going to come there. So I'll know exactly where to go. As seasoned lawyers, the first thing you would need to understand is where do I take my client? Which quote my client is looking at. Now, in Ontario Court of Appeal, it's a three-judge panel that sits together. So when there are three judges that who sit together, it's known as a panel. Motions in Ontario Court of Appeal are heard by a single judge. So sometimes you bring in a motion before Ontario Court of Appeal. Does any, okay, before I continue, what is a motion? What is a motion?
It's a request to the court. You're asking the court to do something.
Yeah, but what is it that, what is the mechanics of a motion? What is it that we are looking at in a motion?
Like if there is a jurisdiction issues or something before the trial, so you ask the court to.
You can also bring in post-trial motions. It's not
Okay.
something that you cannot do.
Okay.
So it's a formal request to the court.
It is a form. Think of a motion as a proceeding under a massive proceeding. I call this so you have one umbrella, which is like your main proceeding. Under that umbrella, you have a tiny umbrella. That's your motion. So within a proceeding, if you have a tiny proceeding to look at a specific problem, that is known as a motion. Like for instance, motion to extend time or motion to that you file during discovery because you think that the other party has not disclosed all documents. Motion because you want to, out of the 10 issues that have been raised, you want summary judgment against three, right? Motion is essentially a small hearing. It's a mini hearing under a massive trial. Motion is a very, very important tool because sometimes all your issues are handled, especially in a massive hearing. You actually go motion by motion under the massive hearing. You're like, let me, instead of taking this as one litigation, break it into 10 separate motions and handle each issue by getting one motion passed. So, in Ontario Court of Appeal, these motions that are passed can be heard by a single judge except three portions. Otherwise, hearings in Ontario Court of Appeal are heard by three judges. When they come together, it's called a panel. All right? It's called a panel of judges. Now, from the panel of judges, they are going to hear the entire matter. But if it is a motion that you're bringing, in Ontario Court of Appeal, it is heard by a single judge. However, there are three exceptions to it, which means if you're bringing a motion for these three reasons, then it will again be heard by a panel. Am I clear here? Or do I need to go over this again? Everybody clear?
I just
Did
had one question. Did we
Yes.
discuss the exceptions? Like, what are the
No,
exceptions?
we are
No,
going to
okay,
talk about it. We are going to talk
okay.
about it.
just a question. Do they also call it like an interim order or different?
No, interim order is different. Interim order is within a hearing when an order is
Okay.
passed.
Okay.
We're going to talk about orders, appeals, judgments, costs, all at a later stage. Right now, because I know this is not the best, it's it's an introduction to civil litigation, not the best uh, subject, not the most favorite subject. Therefore, it's important that we go step by step. Okay, we're going to discuss these exceptions now. RM, I don't know your full name, so
Oh, it's Raghav. Sorry.
Raghav. Okay, I'll
Yeah.
just rename. So, motions in Ontario Court of Appeal are heard and determined by a single judge. That is the thumb rule. What is the exception? These are the three. Number one, motion for leave and appeal. When you're actually asking for leave to appeal against the order passed by Superior Court of Justice, it is you first have to bring in a motion before Ontario Court of Appeal, because Ontario Court of Appeal might say, we don't see any merit at all. So in this case, this matter, this motion will be heard by three judges. Motion to quash an appeal. Well, the other side is filing for an appeal. The winning side at Superior Court of Justice has filed for an appeal. You think that there is no merit in the appeal. So you're now asking, you're requesting the judge, please quash this. So that is called motion to quash an appeal, right? Or any other motion that is specified in your rules. This is like a wide umbrella. Any other motion that is specified. So, thumb rule, hearing is conducted or matters are heard by three judges. That's called a panel, unless it's a motion, because motion is heard by a single judge. However, there are three exceptions, because in case of these three exceptions, again, it's going to be the panel that's going to hear. What are these three exceptions? Number one, when you're asking for leave to appeal. Number two, when you're asking to quash an appeal. And number three, it's a wide latitude, any other motion that is specified. Raghav, does that answer your question?
Yes, thank you.
A single judge also may adjourn a motion and say, I need to bring it to the panel because we need more judges to contemplate. You see, sometimes people go like, what do? They spend a lot of time, because at the end of the day, you're in a common law jurisdiction. What they write becomes the law. So they have massive responsibility on their shoulder. So, it is important that we focus on the fact that writing or passing an order or a judgment is not the best, is not the easiest of tasks. And so that is your Court of Appeal. Now let's come to Court of Ontario, which establishes two courts, Superior Court of Justice, Ontario Court of Justice. I told you, Ontario Court of Justice, it does not have any jurisdiction over civil matters. That's where the matter ends. So it's a provincial court, your Provincial Offences Act, your POA matters, your Family Law Act, CLRA, which is Children's Law Reform Act, the Child, Youth and Family Services Act, CYFSA, where your Youth Court for Criminal Justice Act. Proceedings are performed by one judge. An appeal from here lies to SCJ, except for criminal code, because then it goes to OCJ. You don't have to worry about Ontario Court of Justice at all at this point in time. I'm going to do this when I do criminal litigation. I think those of you who are a regular student, you already have the timetable, right? The tutoring schedule. I know for a fact that Raghav is a regular student. Tabassum, you're a regular student. You already have our tutoring schedule, right?
Yes.
Yes. So please follow that. We will be from our next session onwards, which is going to be for only for our regular students. I'm also going to discuss how to study, because this is a shorter term. Winter term is always the shortest. So we have to study in a certain fashion. We're going to talk about that on our during our next session, which is going to be on Monday at 7:30. Now, when it comes to Superior Court of Justice, once again, there are two types of jurisdictions: original and appellate. All civil trials go before Superior Court of Justice, period. If it's a civil trial, it is going to go before Superior Court of Justice. Now, appellate jurisdiction, all the interlocutory matter. So what is an interlocutory matter? Interlocutory matter is known as an interim matter, right? Like an interim order. So all your interlocutory orders passed by the associate judge or assessment officer about the assessment cost, they are all handled by the appellate jurisdiction. So you might want to know, what is it? What are interlocutory orders? Interlocutory orders are also interim orders. So in a legal proceeding, so you'd see a lot of footnotes here which define terms. It's a legal ruling or decision issued by a court during the course of a legal proceeding before the final judgment is rendered. It addresses specific issues or interim matters that arise during the litigation. So, all your interim orders that are passed by the associate judge or the assessment order about the assessment cost by the assessment officer, these are all appellate jurisdiction. So, let's say the assessment officer says that the cost of this is $5,000. You say that's a lot of litigation cost. I want to appeal against the order passed by the assessment officer. Where are you going to file the appeal? You're not happy with the decision of the assessment officer. Where do you file the appeal?
Just gonna guess divisional court.
Superior Court of Justice.
Superior court.
Superior Court of Justice. The assessment officer has given $75,000 in cost. You're not happy with the decision of the assessment officer saying that litigation costs $75,000 have been awarded to the other side. It's too high. Where do you file an appeal? Where do you file the appeal? The assessment officer has awarded $75,000 in cost. Where do you file the appeal? Give it a shot. Give it a guess. Zira says appeal court. No, Zira. Here is the catch. It does not matter what the assessment cost is. Forget $75,000. Even if it's $1 million, it will go to Superior Court of Justice. The assessment cost can only be appealed before the Superior Court of Justice. Does this make sense to everybody? We are not talking about value of the order. We are talking about cost, assessment cost. Does this make sense? Only to Udshay Raghav. No one else? You're not clear? Angela, AB, Blackberry, Delilah, Ayan, Oki, Rehan, Tabassum, Aarti. Zina, is this clear?
Yes, I thought the value of the cost. Yeah.
Now let me explain the difference. The value of the order means what the judge has awarded you. Okay? You have a claim for $50,000. You file that claim. You're not happy that the judge has given a decision in the favor of the other party. You appeal against that order. You go to Ontario Court of Appeal. It is the value of your claim. What does the assessment officer do? The judge in the order says the costs are going to be awarded to the winning party, right? Which means your opposing counsel. Now, your opposing counsel charges $300 an hour, and along with that, disbursements of another let's say $5,000. So your opposing counsel says the costs are $20,000. You were like, but I'm not happy with that. You're awarding 100%. Like, the assessment officer says, based on the numbers that were given to me by the opposing counsel, their bill is $20,000. Okay. Now you have to pay that also. But you say, I don't agree with this number. So whose number are you not agreeing with? The judges or the assessment officers? Whose number do you not agree with? You're not agreeing with the cost of the litigation. You're saying, fine, I've lost the matter. It's okay. But I'm not happy paying these costs. I'm not happy to pay $20,000 to the opposing counsel. So you're going to appeal against only the cost. You're not appealing against the decision of the court. Do you see what I'm trying to say here? There are two numbers that are at play. One is the value of the claim. You say, fine, I lost. But I am not going to pay opposing counsel $20,000. So whatever assessment costs that have been levied, assessment officer, I don't agree with that. So where will you file an appeal against the order that is given by the assessment officer? Where are you going to do that?
It is before the Superior Court of Justice.
Correct.
One thing I want to know that supposing the SCJ has passed the order, but the cost part will be decided by the assessment officer, and we can challenge the assessment officer's order before the same court by saying it's not right.
Correct.
Yeah. That's okay.
Yes, when appealing against the cost. Okay, now let me ask you a question. A plaintiff files a claim for $60,000 and loses the claim to the defendant. The plaintiff thinks that feels that the decision of the court was incorrect and was flawed and wants to appeal against that decision. Which court will the plaintiff go to in order to appeal this decision? Which court are you going to go to?
Ontario Court of Appeal.
Correct. Now the plaintiff decides, I don't want to appeal against the decision. I don't have the money to litigate further. The assessment officer calculates the costs to be around $10,000. The plaintiff feels that this is unfair and they do not want to pay $10,000 to the opposing counsel. So, where are they going to appeal against the decision of this assessment officer?
Before OCJ.
Correct. Not OCJ, Superior Court of Justice.
SCJ,
Why OCJ?
Superior Court of Justice.
It's a Superior Court. Superior, yeah.
Correct. Now, the plaintiff now wants to again go ahead and file the appeal before against the defendant. The matter goes to Ontario Court of Appeal. The plaintiff has to first bring in a motion for leave to appeal. Who is going to hear this motion?
It's a single bench.
3-judge panel. Remember, motion is heard by a single judge, except this falls in the exceptions, Deepak.
Okay.
Motion for leave to appeal. The defendant feels that the plaintiff has no merit and wants to quash this appeal. In order to do that, the defendant needs to bring in a motion to quash this appeal. Where will the defendant bring this motion?
Before the panel.
Before the panel of
Ontario Court of Appeal.
Ontario Court of Appeal. Now is it clear to everybody? If this is not clear to you, I cannot proceed further. I will have to stop here. Because if you get stuck here, there's no point in going ahead with civil litigation. Ehsan, Vaibhav, Han, Tani, Divya, sweet mother, let me know if you have an issue with my delivery, if I'm going too fast, if I'm speaking too fast, too slow, if my accent is not clear, if how I speak is not clear, please let me know. You want me to use a simpler language? I'm happy to do that. Just let me know if you have fully understood. See, some of you might not sign up with us, and that's fine. But for them, the session has to make the most sense so that they know that at least the jurisdictional part of your course is clear to you. Great. I have already written, please note, it does not matter whether the assessment cost is $1 or 1 million. The appeal against the assessment cost will be before the single judge of Superior Court of Justice. And this we have already done. Now, the judges of Superior Court of Justice can be assigned to any branch of SCJ. Proceedings are heard by a single judge. However, if it is a divisional court, which is a branch of Superior Court of Justice, they are heard by 3 judges. Technical competency area, focus on jurisdiction. Now, let's look at the split. We are looking at divisional court, small claims court, specialized courts. When we look at divisional court, once again, there are 2 types of jurisdictions, original and appellate. Divisional court has the jurisdiction to hear judicial review applications that come from your tribunal, your board, your agency, commission. These are, if you're not happy with the decision of, I don't know, Workplace Safety and Insurance Appeals Tribunal, what are you going to do? You're going to file for judicial review. Where will you file for judicial review? Divisional court. You're not happy with the decision of License Appeals Tribunal. Where are you going to go? Divisional court for judicial review. You're not happy with the decision of Law Society Tribunal. Recently, somebody won. It was called Simon versus Law Society, and Simon won. So, divisional court. You're not happy with the decision of Social Benefits Tribunal. Where do you go? Divisional court. You see, in Ontario, we have a very active tribunal structure, and I will show you where you're going to get this from. Because candidates, they wonder, oh, where are these decisions of the tribunals posted? And I'm like, if I were to tell you, you'd laugh because you already know the platform. Is my screen clear to everybody? Can you see my screen? This is Canly. Can you see my screen, guides?
Yes, screen cam visible.
Okay. Now, let's go to Ontario. Now, in Ontario, you have courts and you have boards and tribunals. So these are your tribunals. You're not happy with their decision? What do? You go in for judicial review. Where will you go in for judicial review? Divisional court. So when you look at divisional court's order, these are essentially, you will see your judicial review matters. Like for instance, you're not happy with the decision of landlord tenant board. You want that overturned. You'll file for judicial review in divisional court, right? So your GR matters are heard by divisional court. You're not happy with the decision of, I don't know, Ontario College of Teachers. You're not happy with the decision of Ontario Fire Safety Commission. You're not happy with the decision of Ontario Land Tribunal. You want to file for judicial review. You see yourself here. Can you see this is your court structure? This is what we have been studying. Ontario Court of Appeal, Superior Court of Justice, Divisional Court, Small Claims Court, Ontario Court Court of Justice. This is what I have been teaching for the last few, like about an hour and 10 minutes now. This is very helpful. So for those of you, before I started civil litigation, I spent, and we got these fancy softwares like your LexisNexis and Westlaw and all of those. And even now, like we have the source subscriptions, but the student of law in me wants to go to Candly. I love Candly. I think it is the single most useful resource that is available at our disposal. Make use of it. So, and yes, for those of you who are internationally trained lawyers who have not had a chance to work with Candly, it's okay. If you get stuck, let me know. There's somebody by the name of iPhone who has just entered the class. Please identify yourself. I'm stopping the recording. So I was talking about Candly. If you guys get stuck in Candly, let me know. But it's a beautiful resource. So, judicial review from the list of boards and tribunals we saw. If you're not happy with the decision, file for judicial review in divisional court. Judicial review application can be brought in any region. Divisional court has another jurisdiction, also known as the appellate jurisdiction, right? Appellate jurisdiction, final decision from the associate judge goes to divisional courts. Those of you who are not familiar with who's an associate judge, don't worry, we're going to talk about associate judge. In fact, we're going to talk about everything that an associate judge can hear. Okay? So, don't worry. Final decision of the associate judge. Orders and damages made up to $50,000. This is what somebody wanted to know. So I have a decision that is given by Superior Court of Justice for $45,000. I am not happy with that decision. Where do I go in for appeal? Thank you. Where do I go in for appeal?
Excuse me, can you repeat the question? Your voice like cut off when you are like when you expose when you say the
Okay,
question you asked.
that's fine. A judge of Superior Court of Justice gives a decision for $45,000. I am not happy with that decision. Where will I appeal that decision?
Divisional court?
Correct. Why divisional court? Because the appellate jurisdiction of divisional court is orders above, is orders, sorry, it orders up to $50,000. By the way, these limits have changed. And the reason they have changed is because now the small claims court does not, the jurisdiction is $50,000, not $35,000. So, but I don't know if they have updated your materials to reflect the change, or they have asked you to look at the new limits. But it is no longer $35,000. From October 1st, 2025, matters up to $50,000 go to small claims court. It is no longer $35,000. And if you're not happy with the decision, you go in for appeal. But, however, I am still bound to teach you $35,000 because from what I know and from what I've heard, I asked if there were any changes to your portal. Since none of you reported any changes, we are going to stick to $35,000. But I can tell you that the matters have, like, small claims court. Yeah, I'm aware of that. Like, I can show you, for those of you who are not clear, the rules of small claims court categorically now say from 1st October. So now, the previous limit was $35,000, but since the materials have not been updated, I am still bound to teach this. So for those of you who are interested in writing, this is the notification. $50,000. And the appeal cannot, like in the previous rules, there was no appeal for orders less than $3,500. Now that amount has changed to $5,000. That's what I'm saying. It is important to understand that I will still be teaching the previous one. Why? Because I have been specifically told, I asked a question if there was any change, and all of you said no. So, because there has been no change, I am still going to be teaching previous one.
I'm sorry, I have a question.
Yeah.
So you said that the limit has been increased to 50,000, but in the exam do we still select the 50,000, right? Because it has
No.
no. Okay.
So, final order made by small claims court, value of the order is less than $3,500. This has been changed to $5,000 now. No appeal lies. So, if it's a final order made by small claims court of $8,000, it's going to go to divisional court. Motion is heard by a single judge unless the rules prescribe otherwise. A panel of divisional court may, on a motion, set aside or vary the decision that is given by a single judge. Then comes small claims courts, jurisdiction where the value of the property does not exceed $35,000, sorry. In case of a counterclaim where the value is $35,000, it can still go to small claims court. Where liquidated damages are involved, which means the damages have been quantified with both the plaintiff and the defendant claiming $25,000 against each other, the value still goes to small claims court. You can hear the monetary suits against the federal government also if the value is less than $35,000. Equitable relief is permitted within $35,000. You can determine questions of law and fact. Proceeding may be heard by the judge of Superior Court of Justice, a deputy judge, or a small claims administrative judge. You have relaxed rules of evidence. You can admit any oral testimony, any document, even hearsay evidence is permitted in small claims court. Think of it as a more relaxed court. You are not to admit inadmissible evidence, however. You cannot accept evidence that's against the very grain of the Evidence Act, and summary judgment is not available. Business-related matters, essentially cross-border proceedings involving commercial and insolvency matters. These are specialized courts. They're only in Ontario. Yes, Rejoice? Rejoice, you raised your hand. What can I do for you?
I'm just thinking of small claims courts, and what's coming to my mind is something like Judge Judy. Is that an example?
What?
Judge Judy's court. Is that an example of a small claims court?
I do not understand the name of the court you're saying. Can you type it down?
Okay, I will.
That's on social media. That's a different jurisdiction. It's in America.
Okay. I cannot comment on the American law.
This
Judge
is a
Judy, is it Ontario? Is it based out of Ontario?
Okay, I'm just having an example, like a practical example in my head. So since it's not in Canada, it's different. Okay.
So I wouldn't know this because I'm not aware. I focus on what's happening in Ontario unless and until it is not even Alberta. So if it is an Ontario-based example, I can tell you for a fact. Otherwise, I wouldn't be able to.
Thank you.
Then you have commercial list. This is only in Toronto. Okay. It's governed by consolidated practice direction. So you have business related matters and estate lists. They're only in Toronto. In any other area, like for instance, if you have a business matter in Oshawa, it's going to go to Superior Court of Justice in Oshawa. If you have a specialized estates matter in Superior Court in Brampton, in Peel region, then that's where it's going to go. Only in Toronto, you have a commercialized list, which is essentially governed by consolidated practice direction. Now, divisional court, I already explained, proceedings are conducted by a panel of 3 judges. Single judge may decide appeal from the final decision of associate judge, appeal from the final order of small claims judge by a provincial court judge, appeal from the final order of deputy judge in a small claims court, appeal from the administrative judge of a small claims court, value of which exceeds $3,500. Like I said, this has now become 5,000, but we are going to study 3,500. The matter is the one that the Superior Court of Justice thinks, or the Chief Justice of Superior Court of Justice thinks, ought to be brought before the divisional court. Motions are heard by one judge unless the rules determine otherwise. Okay? Now, who is an associate judge? Because please remember, I said over here, final decision of associate judge. So your question needs to be, who is an associate judge, Hannah? An associate judge is a provincially appointed judicial officer. Before 2022, they were called masters, case management masters. Now they are known as associate judges. It's a provincially appointed judicial officer. They have the authority to hear and determine certain civil cases, including motions, pre-trials, case conferences. Associate judges sit permanently in Toronto and Ottawa. They have the jurisdiction to hear most motions, except which is a motion reserved by a judge to a judge by a statute or a rule, motion to set aside an order that has been passed by a judge, motion to vary an order that has been passed by a judge, motion for judgment on consent in favor of any party that is reeling under disability. If it concerns the rights and interest of a party that is reeling under disability, the matter, as a thumb rule, will always go before the judge. It will never go before associate judge. Motion relating to the liberty of a subject, any judicial review issue, and any motion to file an appeal will also not go before the associate judge. Any questions here? Any questions here? Is there anything that you've not understood? I'm happy to answer your questions. Muiva, Rehan, Sharif, Ehsan, Zina, Vaibhav, Han, Delilah, Ayan, Tabassum, Arti, Angela, Rejoice.
Understood, Anna.
Okay. So you see, associate judge has a very specific job. They have the jurisdiction to hear most motions, except the ones that are mentioned over here. An associate judge is a provincially appointed judicial officer, and they sit permanently in Toronto and Ottawa. Who is a registrar? Registrar is an official. Give me a minute, please. Who is a registrar? A registrar is an officer under Ontario Public Service. What all can a registrar do? Except for passing consent orders for a party under disability, a registrar can pass consent orders for amendment of a pleading, notice of application, notice of motion, addition, deletion, substitution of a party, removal of a lawyer as the lawyer of record, setting aside the noting in default of a party, setting aside a default judgment, discharge a certificate of pending litigation, security for costs in a specified amount, reattendance of witness to answer questions on examination, fulfillment of an undertaking, dismissal of proceedings with or without cause. So, except for parties, for consent orders that require a party or that have a party that is reeling under disability, a registrar can pretty much pass all consent orders. Who will look at passing the order for a party, for consent order of a party that is reeling under disability? Who will do that? If a party is reeling under some sort of a disability, if they're suffering from some sort of a disability and a consent order has to be made, who will make it?
A registrar.
The opening sentence.
Judge.
Always the judge. Always the judge. If the part, please write this down if you want somewhere. If a party is suffering from any kind of disability, any orders pertaining to that party are going to be passed by a judge, not by an associate judge, not by a registrar, nobody. When the party is under a disability, consent order means the order is being drafted based on the consent of both the parties. It's not being contested. So let's say the consent order can be to delay the matter, giving each other time. Any questions, anybody else? Any questions? A is suffering from Alzheimer's. A needs, or A has been filed, or a lawsuit has been filed against A for vacating their property. Who will hear this lawsuit? Who will hear this lawsuit? Or a consent order has to be filed between A and B, where A is a party reeling under Alzheimer's or suffering from Alzheimer's. Who's going to pass this consent order?
Judge?
The judge. Can the
Judge.
registrar pass it?
Sorry?
Can the registrar pass this consent order?
No.
No.
No. Thumb rule. There are some, so I always say this, civil litigation can be very simple if you just recognize the thumb rules. Like pecuniary jurisdiction is a thumb rule. You can never forget. The fact that a party requires a litigation guardian and therefore any and every decision for that party has to go through the hands of a judge, including settlement offers. Thumb rule. They're going to go through a judge. It doesn't matter. Associate judge cannot hear anything or cannot set aside, vary, overturn a motion that has been passed by a judge. Thumb rule. If it's a specialized matter related to estates and it is in Toronto, they have a specialized court. Thumb rule. If the same matter were to originate, let's say in Thunder Bay or Sudbury, it'll go to Superior Court of Justice. Thumb rule. Civil litigation has a lot of thumb rules. If you won't forget them, like I always say, if you get it, you'll never forget it. You just need to get those thumb rules. Then they'll stay with you. Believe me. While I was studying for my barristers, I had these thumb rules. And when I started my practice, I started practicing like a couple of years ago, including my articling, like excluding my articling, which was almost for 12 months. Uh, when I started, so almost 3 years, I had these thumb rules. You can never forget. Like you'll automatically know where you need to go. But that's the point. If there is any mismatch in your understanding, then there is a problem. Then you will not be able to really process what needs to be done. The idea is once you get it, you'll never forget it. Remember these thumb rules and you'll be good. Case management. Now, Rule 77 of the Rules of Civil Procedure talks about the case management. Case management is essentially a process where, you are managing the case. So you go like, what does it mean? It means procedurally you are managing the case when it comes to scheduling and timetable. And this is offered when the matter is very, very complicated. It involves 15 parties, $200 million at stake. Because of the complication of the matter, because of the number of parties involved, now you want the parties to be handheld through the process so that you can simplify the process. This process, where the scheduling, the procedure is simplified through the mechanics of management, is known as case management, right? This occurs prior to trial because once the matter has gone into trial, it's pretty straightforward. So there are two distinctive features of cases that are placed into case management. Number one, they are managed by a single judge or an associate judge who's also listening to all the motions. And number two, they use a lot of case conferences, which is more like and less than a formal hearing where the judges are trying to decide the next step. So essentially what happens, the judge will say, let's all get together on a case conference. I'm going to call all of you over a phone and let's sort this out. Let's figure out what are the next steps. So what's happening here is that it is a less formal way of ensuring that you're able to chart out the entire process before you take the next step. So think of it as somebody is trying to view your matter with a tunnel vision. They're trying to draw, sketch it out for you. This one will go first. This one will go first. Don't you have time for this? When do you have time for this? Let's figure this out. Bring a motion over here. We'll discuss this. So you're trying to give some sort of a method to madness. They are typically case conferences in case of case management are held by teleconference and they are used to address procedural, timetable and other issues to avoid the need for less formal motions, make it less expensive, so on and so forth. Once again, it is applicable to cases in Ottawa, Toronto, and Windsor. Now, let's look at, I'm sorry, simplified procedure. If your matter is more than $200,000, right? You will go under ordinary procedure. This limit will change to $500,000 once the new rules kick in. So if your matter is less than $200,000, simplified procedure, mandatory, you don't have a choice. These $200,000 do not include your interest and cost. If the matter is above $200,000 and the defendant says, I'm not objecting, go in for simplified procedure. So they are not objecting to simplified procedure in statement of defense. You can still proceed under simplified procedure. So in this case, while the value is above $200,000, the defendant in their statement of defense is not objecting to simplified procedure. Again, you go for simplified procedure. Simplified procedure is not available in case of class proceedings, in case of construction liens, case management cases under Section 77, or where you have a jury notice for slander, libel, malicious arrest, or false imprisonment. So in certain matters, simplified procedure is not available. But don't worry, we have an entire session on simplified procedure. I will talk about them as we progress. Now let's look at PR aspect. I said there is no way you can study something without attaching it to PR. So the first thing you have to check is, do you have even the authority to start civil action against the person? If you do that without authority, you are personally liable to pay costs. So you need client's explicit authority to proceed, right? Which means we are looking at a signed retainer here or an engagement letter. So a signed retainer or an engagement letter is what we need. This is as per the rules of civil procedure, Rule 15. You have to have the explicit authority to commence the action. Now, the lawyer has received explicit authority, but you also need to check whether the person who is giving you the authority has in fact the capacity to act. So you're going to check if the corporation is incorporated and a lawyer's retainer is authorized. If it is a corporation, like for instance, we represent quite a few corporations. The first thing we check is send us your articles of incorporation, send us the board resolution if you have, if you're not a single shareholder or a director. If that's the case and the person has contacted us, then we don't really need it. Let's say there are 3 directors or there are 4 directors and there are 6 shareholders, then we ask for board resolution. We also check if they are in fact permitted to carry on that specific litigation. We check their articles of incorporation. We also do a corporate search to check the current status of the corporation. So we need to check whether the corporation is still alive or has it been dissolved or wound up. Whether the person who's giving us the instructions, do they even have the authority to give us the instructions or not? Unless they are they are the sole shareholder and director, in which case we don't need to see the board resolution. We actually ask for board resolution if there are 3 directors and 5 shareholders, or 2 directors and 3 shareholders. We ask for board resolution. Give us the board resolution that in fact authorizes you to give us instructions. Because for a corporation, you have to be very clear who will give me directions. Because I'm not going to take instructions from 20 people. Very clear, right? If it is an estate, check if the estate trustee has the authority. You can find this in the will. You can ask for certificate of appointment of estate trustee with a will. Check with all the estate trustee. If it is an agent, the principal must provide authorization. You will have a typical principal-agent relationship in case of an employer-employee situation. If it's a person with diminished capacity, check if they have a valid litigation guardian. It's not just about whether you have the authority to act. It is also about that the person authorizing you to act should also have the authority to give such an instruction. So you're essentially doing checks at two levels. Do I have the authority to act? Yes. But did this person have the authority to instruct? Yes. Now I can proceed. Because even if one is weak, beware costs can come on you. If your client is an undischarged bankrupt, the litigation will be a nullity unless there is a claim for wrongful dismissal or the personal, if it is a matter such as a personal injury. What if the client dies? If the client dies, then the lawsuit can only continue after you have received the consent of the estate. Otherwise, you cannot continue. I had this situation where, in the middle of a workplace safety and insurance claim, it was a matter that was supposed to go before the tribunal, and right before that, the client was no more because they were suffering from prostate cancer. So they were no more. And when I spoke with the survivor, who was their widow in this case, she said she does not wish to pursue. She wishes to withdraw. Then I had to take written instructions from her saying that she wishes to withdraw, so on and so forth. And I also said, give me the certificate of appointment of a state trustee if you've been made an estate trustee. So we informed the tribunal that the client is no more and that we are going to get back once we get the instructions from the estate. This surviving spouse, went to Superior Court of Justice to get a certificate of appointment of a state trustee with a will. And fortunately, our client had prepared a will in which she was the sole beneficiary and the state trustee, because our client did not have kids. And she sent three things I remember still. She sent proof of death, certificate of funeral service, order from Superior Court of Justice, which was essentially a certificate of appointment of a state trustee with a will, a copy of the will, and a letter saying that she wishes to withdraw. Then we had a telephone conversation with her. I remember having that. I prepared a detailed memo. Then I wrote a letter to her saying that I'm in receipt of these documents and that based on your instructions, I'm going to withdraw. And once I shared that letter with her, I attached all of it and uploaded it on the tribunal's portal, called up the scheduling clerk, cancelled the hearing, and then ensured that the tribunal closes the file. And then finally, we had to close the file at our end. So it is an entire procedure that you need to follow. If your client is no more, you need the estate of, consent of the estate to continue. And had this been the situation where she said, no, I want to pursue, then she would have sent a letter saying, pursue the claim. And then we would have had to inform the tribunal accordingly and say, now that the person is no more, we are going for a written hearing because we do not have oral testimony. So these are the procedures that you need to be fully aware of. Communicating with the client. Tell your client that litigation is expensive, time consuming, and stressful. It is your mandatory duty to encourage the client to resolve the matter through non litigation route. You can do it any time before the commencement of legal action or for commencement of legal action before the trial. Mediation, arbitration, settlement, negotiation. These are the various forms of alternate dispute resolution. So pursue ADR first. The first step is negotiation. If negotiation fails, then try and go for mediation. You can select a mediation coordinator. You have rosters there. If that also fails, then you can, if it's a contractual dispute, then you can go in for court. But you cannot go directly to court without having, I mean, you can, but going through ADR is the best possible. It is highly recommended. ADR is a separate competency on which you will be tested. Please do not ignore this, even though the section might not appear to be extensive. Withdrawal of service. When you are a lawyer of record, you will have to follow the rules of professional conduct to withdraw. There is no way you can say, oh, I only need to know the litigation process. PR is a very important component. So you will terminate your relationship only on good cause and with reasonable notice. You will not go cold turkey on your client, and you are going to continue to represent till the time you are quote unquote fired, right? If the lawyer chooses to withdraw, you must comply with the manner of withdrawal, which, by the way, when we are going to do criminal litigation, you would realize there are specific steps of withdrawal that you need to file. So you will give a complete notice, detailed information, the reason of withdrawal, and why are you withdrawing. However, when it comes to withdrawing and you need to let the opposite party and the judge know, please note, you are not under an obligation to give them more information that's necessary, but you still have to have a detailed memo as to why you withdrew. So that tomorrow, if your client goes to the law society and says, well, they were not supposed to withdraw, you have a detailed memo to back your decision. Now, when you are looking at seeking information from your client, please be aware that you are governed by a legislation that is known as PIPEDA. It is a privacy specific legislation, which is by federal law. I've PIPEDA is essentially a federal legislation which is applicable in Ontario. I can tell you a lot of provinces have their own privacy legislation. Some of the most advanced privacy legislation, which is better than PIPEDA, is of British Columbia. I was, in fact, working on a matter that required me to do an environmental scan for all the privacy legislations that are in all the provinces. So I pretty much had to go over your entire provinces and territories. Some of the provinces have their own, like Alberta, Quebec, British Columbia, and some have simply adopted PIPEDA. So I had to then look at which is a stronger privacy legislation. This I was doing during my articling. I had to prepare a memo on a very specific case law that talks about privacy legislation. I still remember it was a very interesting exercise that I had to do. And I found that privacy legislation of British Columbia, outstanding, beautiful. PIPEDA is okay. I'm not saying it's bad, but it does not come close to BC's. Their consent and capacity tool and their privacy legislation. It's sterling. Like you heard of sterling silver, it's that. But anyhow, in Ontario, we follow PIPEDA. PIPEDA is going to be applicable even to you if you will run your own private law firm or if you are a solo practitioner, because that legislation is going to be applicable to you. It is not applicable, so I also work for the province. It is not applicable to you when you are a provincial employee or you are like, you work for municipality. So the government sector, it's not really applicable, but it is applicable to the private sector. So PIPEDA does not apply to federal government, provincial government, municipality, and not-for-profit organizations, which means it is very specific to businesses, commercial undertakings. PIPEDA will not apply where litigation is between two individuals and the matter is of a personal nature. PIPEDA applies in the context of commercial litigation where entities are commercial entities or where it is difficult to assess. Consent should be obtained and personal information should be de-identified wherever possible. Now, like I said, PIPEDA applies to 1 second. Okay. PIPEDA applies to every stage, whether it's gathering information, pleadings, discovery, factums, publishing findings, assessing solicitor-client relation. So let's say if you want to put the opposite party under surveillance, this usually is done by insurance companies to check whether the party's injury is in fact if that injury is truly has truly impaired the person or not. So they put the parties and gather surveillance evidence. They collect evidence only that's necessary. You cannot take more evidence than necessary. No knowledge or consent is required if accuracy is compromised. When it comes to pleadings, again, you have to disclose minimum amount of information. You're not really going to disclose their social insurance number. You're not going to disclose their personal bank details. Other things. Make amendments as soon as possible if you think you have disclosed more information than necessary. When it comes to discovery, this heightened PIPEDA obligations, especially in the context of electronic devices like phone, WhatsApp chats, no. As a lawyer, you will come across information that is strictly personal, right? And there's something called the deemed undertaking rule, which is essentially means you're not going to use this information for any purpose than what's stated. And if you do, ooh, you can lose your license. Factums, again, it cannot include personal information about the individual. You have to avoid, I've mentioned, no personal identifiers like account numbers, etc. And redacted versions need to be submitted. Publishing findings, disclose information without consent that is publicly available. That is something you can do. Decision letters, reports from Privacy Commissioner of Canada that aren't publicly available should not be disclosed. There is a reason they're not publicly available. And if if accessing solicitor-client relationship, well, commissioner may investigate, but the commissioner cannot compel you to breach solicitor-client privilege and cannot make binding orders. You have to assert privilege on behalf of your client. Commissioner, if they deem appropriate, they can apply to a federal court for a hearing on the matter, asking you to disclose information. But please note, you have to guard solicitor-client privilege with your life. There is no way you're going to divulge that information unless it is as you have certain exceptions, and we are going to talk about exceptions both under civil litigation and PR. So if let's say you find that there is some sort of a leakage or there's some pilferage of important information, complain to the commissioner, investigation by the commissioner. Commissioner cannot make binding orders and they cannot compel production of records for which there is a barrister-client privilege. The commissioner has to file a response within 30 days and apply to federal courts for hearing in case there is an issue. Now, I'm not going to start pre-litigation protocols today, which is essentially your preliminary matters, because this is something that we're going to do on Monday. I'm going to really enter into very technical area here where we're looking at time limits, so on and so forth. This is reserved for Monday. So for those of you who are our regular candidates who already have access to my recordings, please go over the lecture that talks about pre-litigation protocols, which is your preliminary matters. We're going to finish that on Monday. I'm also going to I'm also going to look at who can be sued, who can sue, confirm the identity. This is rules 7, 8, and 9 of the rules of civil procedure. This will also be combined with bylaw 7.1 of PR, because that's where we're looking at start talking about identification and verification steps and protocols. These two things we are going to do, and we are also going to talk about joinders and interventions. Like for instance, recently you must have heard that Black Legal Action Center was asked to intervene in one of the matters by divisional court judge. That became a huge issue. I'm going to discuss that as well. Rule 13. So these are the three things we are going to do. We are going to aim to finish. And then next Saturday, we're going to land ourselves in starting the proceedings, because these, whatever we would have discussed, would have constituted our before litigation bucket. If you remember, I said here, your before commencing litigation. This is your before litigation process. So today we actually did this, understanding the court organization and jurisdiction. In the next class, we are going to check point 2, 3, 4, 5, appropriate forum. We did this today. What happens if the claim is less than $200,000, identifying the parties and parties reeling under disability. So you would see your before litigation protocols need to be done between Monday and Saturday. Please go over previous recordings so that you have a fair opportunity to go over the concepts before we do them in the class. And now let's look at some practice questions. I have a request. I have a very bad throat. Can somebody read the questions, please? Like, I'll show you the questions. Can somebody read the questions instead of me reading the questions? Can somebody volunteer? I really have a bad throat. Can somebody volunteer, please?
Yeah, sure, I'll do it.
Thank you so much, Raghav. Yes. Raghav, can you see my screen?
Yeah, I can. Question number one. Maria, a plaintiff, initiates a civil lawsuit against a contractor, Buildright Constructions, alleging breach of contract for failing to complete a renovation project. Maria serves the statement of claim on Buildright Constructions, but she mistakenly serves it to the wrong address, even though the correct address is listed in the company's articles of incorporation. Buildright does not file a statement of defense within the required time limit, as it never receives the statement of claim. After the deadline for filing a statement of defense has passed, Maria applies for a default judgment. Buildright Constructions, upon discovering the claim, files a motion to set aside the default judgment, arguing that the service of the statement of claim was invalid due to the incorrect address. Buildright also asserts that they have a valid defense to the claim and they were prejudiced by the failure to properly serve the claim. Maria argues that the issue is a mere irregularity and that the court should proceed to determine the substantive issues of the dispute. Under the Ontario Rules of Civil Procedure, which of the following is the most likely outcome regarding Buildright Construction's motion to set aside the default judgment? A, the court will set aside the default judgment and allow Buildright to file a statement of defense, as the incorrect service is considered as irregularity that can be remedied under Rule 2.01, Subclause 1. B, the court will not set aside the default judgment, as the failure to properly serve the statement of claim constitutes a fundamental flaw that cannot be remedied by the court. C, the court will grant the default judgment in Maria's favor, as Buildright failed to file a statement of defense within the required time limit, and the service error is irrelevant. D, the court will set aside the default judgment only if Buildright demonstrates that they were prejudiced by the improper service and that the defense raised is frivolous.
What do you think? Okay. Yes, Rejoice. A is the right answer. Because incorrect service is considered a mere irregularity that can be remedied. A is the right answer. Yes, Harsha. Yeah. No, this is not something that we've covered right now. Okay. Hmm. Okay, let's want to go to jurisdictional questions. Just give me a minute. Yeah, got them. Yes, please continue. Can you see my screen, Raghav?
Yeah. Okay.
Yeah.
Okay, James Carter and Emily Turner are involved in a civil dispute over a contract for the sale of goods. James Carter sued Emily Turner in the Ontario Superior Court of Justice, seeking damages for breach of contract. The Superior Court ruled in favor of James Carter, ordering Emily Turner to pay $50,000 in damages. Emily Turner appealed the decision to the Ontario Court of Appeal, arguing that the Superior Court had erred in law. However, Emily also raised a constitutional issue, arguing that the contract terms violated her rights under the Canadian Charter of Rights and Freedoms. The Ontario Court of Appeal, while addressing the appeal on the contract issue, acknowledged the constitutional issue raised but did not rule on it. Instead, the Ontario Court of Appeal, on its own motion, referred the constitutional issue to the Lieutenant Governor in Council to determine whether the issue should be considered by the Court of Appeal. The Lieutenant Governor in Council then referred the constitutional question to the Court of Appeal for determination. Which of the following statements is most accurate regarding the Court of Appeal's jurisdiction to address the constitutional issue? A. The Ontario Court of Appeal does not have jurisdiction to hear the constitutional issue unless it was first addressed by the Ontario Superior Court of Justice. B. The Ontario Court of Appeal can address the constitutional issue only if the Lieutenant Governor in Council refers the question to the Court of Appeal under its original jurisdiction. C. The Ontario Court of Appeal cannot hear the constitutional issue because it only exercises appellate jurisdiction and cannot rule on constitutional matters. D. The Ontario Court of Appeal has jurisdiction to address the constitutional issue because the Lieutenant Governor in Council has referred the question to it under its original jurisdiction under Section 6 of the Courts of Justice Act.
What do you think is the answer? Constitutional questions. Go to Ontario Court of Appeal. Remember, we had done.
Yeah.
So D is the right answer here. Because Ontario Court of Appeal has the original jurisdiction to hear all the questions it gets from either the cabinet or the Governor General. Sorry, Lieutenant Governor General in Council. Yeah.
Question 3. Okay. Diana Patel was involved in a civil dispute regarding her contractual agreement with George Roberts. After a ruling in the Ontario Superior Court of Justice, Diana Patel decided to appeal the decision. Diana filed her appeal in the Ontario Court of Appeal on March 1st, 2025. On March 10th, 2025, Diana Patel filed a motion for leave to appeal to the Court of Appeal, seeking permission to appeal the decision. The motion was heard by Justice William Thomas, who, after considering the submissions, denied the motion. Diana Patel believes that the ruling was made in error and would like to challenge the decision. Diana now plans to bring the motion before a panel of the Court of Appeal to have the decision varied or set aside. Which of the following statements is most accurate regarding the procedural aspects of Diana's motion in the Court of Appeal? A. Diana's motion for leave to appeal can only be heard by a panel of 3 judges as required by Section 7, Clause 1 of the Court of Justice Act. B. Since the motion for leave to appeal was heard by a single judge, Diana Patel may bring the motion before a panel of the Court of Appeal, which has the authority to set aside or vary the decision of the single judge. C. The Court of Appeal cannot hear Diana's motion to challenge the decision because only a panel of judges is authorized to hear appeals, not motions for leave to appeal. And D. Diana's motions for leave to appeal must be heard by a panel of 3 judges, as motions are always decided by at least 3 judges in the Court of Appeal.
What is the answer here? You think so, Harsha? D is the right answer? What was the thumb rule? Let's go back. Except for motion for leave and appeal, right? So it will be heard by 3 judges, correct? Why will
Yeah.
it be heard by a single judge? Answer is A. Diana motion's appeal to leave can only be heard by a panel of 3 judges because it is leave to appeal. All the other motions apart from these 3 are heard by 1. We mentioned this, right? Didn't we? A is the right answer. Okay, continue. I told you, even after going over jurisdictions, you guys will make mistakes. Yeah, continue.
Okay. Jonathan Lee and Sophia Grant are engaged in a civil lawsuit regarding a breach of contract. The case is being heard in the Ontario Superior Court of Justice. On March 1st, 2025, the associate judge handling the matter issued an interlocutory order compelling Jonathan to produce certain documents by March 10th, 2025. Jonathan disagreed with the order and filed a notice of objection to the assessment of cost related to the interlocutory motion, claiming that Sophia's motion was unnecessary. On March 12th, 2025, Jonathan filed an appeal from the associate judge's interlocutory order and the assessment of cost with the Ontario Superior Court of Justice. Which of the following statements is most accurate regarding Jonathan Lee's appeal? A. Jonathan Lee is not entitled to appeal to the associate judge interlocutory order to the Ontario Superior Court of Justice because the interlocutory orders cannot be appealed in that court. B. Jonathan Lee is entitled to appeal the interlocutory order of the associate judge to the Ontario Superior Court of Justice, as the court has jurisdiction over such appeals under Section 17, Clause A of the Court of Justice Act. C. The Ontario Superior Court of Justice cannot hear Jonathan Lee's appeal from the assessment of cost, as cost assessments are always final and cannot be appealed. D. Jonathan Lee can appeal the interlocutory order and the assessment of cost directly to the Ontario Court of Appeal because the Superior Court does not have jurisdiction over such matters.
What is the answer?
I think A, if I'm not wrong.
Why? I told you, no, till the time your
B.
jurisdiction is not clear,
B.
you won't be able to proceed further. Let's go to interlocutory orders passed by the associate judge or assessment order. This is the exact answer. Answer is D. Can appeal the interlocutory order and the assessment order. Sorry, no, does not in Ontario Court of Appeal.
It goes to the SCJ, if I'm,
SCJ, exactly. B.
yeah.
Sorry.
Oh,
B
B.
is the B is the right answer. Yes, B is the right answer. Okay, with this, we come to the end of our session. I hope you found this session useful. This was our free and introductory session. Our next session, which is going to be on Monday at 7:30 in the evening, is only for our regular students. Tomorrow, we are meeting at 9 a.m. Eastern Time for our free and introductory session on business law. And I bid you all goodbye. You guys take care. Those of you who are interested in solicitors, please please keep an eye on Free Ontario Bar Group for the link. And for the rest of you who are planning on writing civil education, who are already with us, I'm going to see you on Monday at 7:30. For those of you who are not with us, but are planning to sign up for the sessions, please speak to Amar. For those of you who are not with us and would like to prepare on their own, all the best for your exam. Take care and bye-bye.